Hi everyone. Just working out some last minute technical glitches here. Jeremy is having a little bit of trouble with his webcam, and we're gonna start recording as soon as that gets going. Welcome to Strategies for Winning Proposals After Proposal Submission and Award. So last time in our series, we have tackled what do you do after the RFP is released? How can you affect the outcome, even though you're no longer in this active pre-RFP capture phase when you're interfacing with the customer, when you're able to shape the RFP requirements, when you have time to develop your win strategies, do customer messaging, and all kinds of other things. So there's a fair amount of material out there, even from OST on that. But last time what we have tackled is the stuff very few people really talk about is how do you really shape things once the clock has started on the proposal process. So today we're going to continue in that same vein and say, okay, well, what can you really do once the customer has announced the award? And we're going to start that with recapping a little bit and updating a little bit of the previous material. And then we're going to dive into the content that every business developer really needs to know that's highly relevant to our field. So let's talk about the presenters. I'm Olessia Smotrova. I'm the fellow of the Association of Proposal Management Professionals, and I have more than 20 years of experience in business development, communications, and marketing. I have wrote the book on how to get government contracts. I have a slice of $1 trillion pie. And I've served for 2 years as the president of the NCMA Bethesda Medical Chapter and 2 years as the president of the Association of Proposal Management Professionals, National Capital Area Chapter. This is truly a passion for me, business development. And prior to OST, I worked at Raytheon, Lockheed Martin, and worked for the Financial Times of London. OST has won more than $22 billion for our clients since 2005, and that's not IDIQ ceiling values, that's actual dollars. And we have 3 lines of business. The GovCon incubator that helps really small government businesses grow with targeted mentoring and classes that are custom made for the needs our members have, and other things like pipelines for the really small companies. The Proposal Academy, where we have over 18 different courses, and we customize them also for companies on every aspect of business development, and of course BD consulting. Jeremy, why don't you introduce yourself?
Well, I'm sorry to everybody that I'm sort of this mystery man today in the in the black box, but maybe we'll get it fixed before we're done. So I'm Jeremy Scholtes. I work with Miles and Stockbridge. I'm in particular in the Frederick office, but we have offices in Baltimore, Washington, D.C., Tysons, Towson, Frederick, Rockville, and Easton. Our focus is principally the East Coast, but when it comes to government contracting, intellectual property matters, and some other related work, we really have a national presence and to some extent also international. But our primary focus is in on the Eastern Seaboard, really from New York down into the Carolinas. I specifically work on government contracts matters and a fair amount of litigation as well, all sorts of commercial litigation. I was active duty Army for about 13 years and actually I'm still now a reservist. But in my private practice, I also still maintain my TS SCI, so I can assist with classified matters that you or any other business may have. On the government contracting side specifically, I work on all sorts of different things, whether it's reviewing contracts, resolving subprime disputes, claims with the government, bid protests, obviously, which we'll talk about at some length today, and then all sorts of other things that pop up in your space. So it's a pleasure for me to be co-presenting with Olessia today. And at our last presentation, I also work with NCMA and had a presentation in April up in the Frederick chapter concerning contract terms, and it's going to be a good presentation today. So let's get started.
All right, let's get started. So last time we talked about how important it is to participate in the debriefings. Whether you lost or won, you always have to make sure that you're participating and requesting the debrief materials. Jeremy, why don't you update us on what has happened as far as the new rules for the debriefings?
So the 2018 NDAA identified a number of steps that the government wants to take, and some of which are now implemented. One of those is concerning debriefing. So as you see on the first bullet there, we've got post-award debriefing rights for DoD procurements. This isn't for every conceivable protest, but the goal here is to try to give more information up front to a potential protester, to all those offerors out there, so that they have a better understanding, we all have a better understanding about why we didn't get the award. And the concept is that if we have more information and can then appreciate that while we're dissatisfied with not getting the award, there are pretty good grounds for why company A got the award and we didn't. And instead of contractors spending a lot of money on the protest process, slowing down the system, potentially automatically staying the performance of the contract for the awardee, and really gumming up the agency's processes, we might be able to see, hey, there really isn't a reason for us to protest. So in our case, we might also be able to identify additional grounds for protesting that we wouldn't have previously. And you really see in the second bullet what it is that we get additional here that we didn't previously have. So if there's a mandatory debriefing or we ask for one, the debrief occurs, then there are 2 business days for us to submit additional questions, and then the agency has another 5 days to respond. And the receipt of the response from the agency is what triggers the period then for us to make a determination of whether we're going to protest or not.
And let me just kind of ask you for a follow-on question. So when you, there you are, it finally popped up, Jeremy.
Oh, I don't even see myself on my own yet. Good.
So,
well, I look good anyways.
So all right. So let me see here, and there's a question here from the audience. This question is: does this flow down to the services, or is it just the DoD itself?
At this point, it's DoD. So that would be any of the, if by services you mean Army, Air Force, Navy, Marine Corps, yes, it flows down.
And I have another question. What are the source documents like FAR that changes the debrief rules? Is it something that's already changed as a rule? Like, is it something that's being implemented, or is it something that will be implemented once they figure out how to implement it?
Well, the piece that has been implemented already, which we'll discuss on another slide, is the filing a protest on the computer. This is coming up really fast, the implementation of this, and you will see it implemented into the rules. I don't think they've actually, I mean, you'd see it in the I think it's in the CFR right now, but we haven't seen it already implemented across all of the federal documents.
All right, yeah, and so I guess to just comment to everyone in business development who is on this call, it's very important that anytime you bid on something over $10 million to DoD now, you should request the redacted SSDD. It just is going to improve the way you do business with this particular customer. You're going to get to know better how they evaluate proposals. Therefore, you're going to be more likely to win the next time, even if you didn't win this time. So it's not only for protest purposes, it's incredibly useful. This is capture gold where it comes to your knowledge of your customer. All right, let's go ahead and talk about post-award protests. So the plan here, what we're going to address is who can protest, the initial considerations, where, which jurisdiction you're going to go into, when, the timing and deadlines, how, the process, why, and Jeremy is going to talk about the common grounds for protests, and then what is an intervener and what are the potential outcomes. So we're going to dive into who can protest. So tell us about that, Jeremy.
Sure. So the bottom line is an interested party. And what is an interested party? Well, if you are one who has submitted a proposal and you did not receive the award, but you at least have a substantial chance of receiving the award if your protest grounds were sustained, then you are that interested party that has the right to it, and the agency has the ability to transition the contract to sustain the GAO has the ability to sustain it, and then the agency would award it to you. Really, it's the substantial chance of receiving the award that is key, because you can't just protest because you don't like the outcome. I'm mad because I didn't get it and I spent a lot of time and money preparing and submitting my proposal. The bottom two bullets on there about counsel, this is important because particularly with the GAO protest, you will have the ability to get more documentation, and all of which would be unredacted. Well, I shouldn't say all of it would be unredacted, but as to the awardee and your information, or if it's a situation where there are multiple awardees, those other 2 or 3 or 4 awardees, you'll get all the unredacted information, their proposal, their the source selection, evaluation documents, all leading up to the decision document. So if you go without counsel, you're going to get fewer documents, and the ones you get are going to be redacted. And that's really a function of protecting proprietary information. You would want the same thing if you were the awardee. But with counsel, we can review all of that. Typically, it will be subject to a protective order. And what the protective order does is it allows me as your counsel and all of my team. So at Miles and Stockbridge, for example, there are 30 of us here who are working on government contract matters. If there are 3 of us working on that particular protest, we'll all be signing off on individual protective orders, and then we are subject to maintaining the confidentiality of the information we're going to get. We can only keep so many copies of it, and then once the protest is concluded, we have a limited period of time in order to destroy all of those documents. The challenge.
Jeremy, can you hang on just a second? Can you go ahead and explain what a protective order does? Like, why is this important to understand what it is?
The protective order is important for the awardee in particular, really any party whose documents are going to be disclosed to anyone other than the agency, that the individuals who look at it cannot be sharing that information with the public. That's critical, because if I'm assisting you in a protest and the agency provides me documents which include the entire proposal from the awardee, I'm going to have all sorts of advantages going forward because of the information that I see there. I cannot share it with my client. So if I'm representing Olessia in a protest, I'll be able to see it all. And then I have to be able to figure out how to craft questions that I can ask Olessia to best understand how to proceed with what I'm looking at without actually sharing that information with her, because she would have a decided advantage going forward on knowing exactly how the awardee is going to go about performing the contract. Different types of information that they would have, proprietary information, information about the company in particular, and resources they have. So you don't want that shared across the industry.
And yeah, and the one interesting thing, just for everybody who's on the call, is it's not only the attorney, it's not only Jeremy that would be looking at the competitor's proposal, who may be the winner. It's also Jeremy would probably go out and hire an independent expert witness who is a proposal expert, who will be able to analyze that and then give Jeremy some insights as to what they're seeing there, whether they're, they're confirming the findings. That generally is the process.
There are times where the technical aspect may be so complicated that despite the fact that I'm a good attorney, I may not be, well, I'm certainly not the technical expert. And if I can't come to my client and explore all of the intricacies of what the awardee has submitted, I need a party who does have that technical knowledge to be a consultant to assist. And then the consultant signs off also on the protective order.
Yep. So now there are different forms and jurisdictions to consider. So we have agency, government accountability office, and Court of Federal Claims, which we're not going to cover a lot in this presentation, but we're going to talk about it some. So let's talk about this one. The agency or GAO, how do you choose?
Well, very generally, on the right side of your slide, what you see up right now are some of those basic considerations. A lot of clients will be concerned about kind of the political aspect of it, for lack of a better term. If I submit this proposal, is it going to have negative consequences for me, either on this contract or on some future contract? Is the Army going to be mad at me because I'm protesting? And is my company then going to suffer the consequences of that? And I would say no. Is it possible? Certainly it is. It's humans who are behind the agency who are making decisions. But large companies, in particular, are protesting with great frequency, some a whole lot more than others, and they're still getting plenty of business. The key is that you really have colorable grounds for why you're protesting. You might lose, but if you're on point and there's a good basis for the protest, then I really wouldn't worry about the political piece. Costs are certainly a concern, but depending on the size of the contract and how complex everything is, how much we're going to have to put into the protest, and supplemental protests, and if hearings are requested and granted, costs can go up. Of course, if you file with the agency and then you protest to GAO and you don't succeed and you go to COF-C, I mean, the costs obviously are increasing as you go up. But it's a business decision really to evaluate what do you have in it, what more are you willing to put in it, because if you have good bases for your protests and you can win, well, the dollars you put in up front are well worth it. So why would you file your protest with the agency? It's certainly a more informal process and generally doesn't cost as much. It happens relatively quickly, usually in about a 30 to 35 day window. The downside is, unless you really have some fine points to get after where the contracting officer or the level above the contracting officer can really say, oh, wow, you're absolutely right. The awardee's proposal came in late. Or, yep, we are looking at our documentation and we can see that we did not follow our own evaluation criteria. That's when you're going to get corrective action by the agency. Otherwise, you're going to the decision maker that made the decision about the award and you're saying, hey, you should change your mind. And going through strengths and weaknesses, it's not going to cut it. So that's where typically we'll say, I would say more often than not, we go directly to GAO. And we'll discuss other considerations that are at play as we go through some of these slides. But a key one is that if you're wanting to stay performance of the contract by the awardee, you're on a timeline.
And Jeremy, real quick, the stay, just
yeah.
to make sure that everybody understands the terminology. Stay means stop, right?
Right. So a stay, it's often referred to as the Competition in Contracting Act, CICA stay. So it is a situation that's automatic if you have timely filed your protest, where performance by the awardee is stayed. It's stopped. Nothing can happen. They can't start doing the work under the contract. And of course, the concept is if they started the work and you submitted your protest to GAO and it takes 100 days for it to be resolved, almost 4 months, there may be a substantial amount of work that's already been done under the contract by the awardee, the initial awardee. So even if you win your protest, a whole bunch of work has already been done. And depending on the duration of the contract, you might be in a position where you really won nothing, or a whole lot less than what you thought you were going to win. Let's see, what else do we have? Oh, very key is that last point under the GAO bullet about short deadlines. We won't go through every aspect of a protest today, but it is critical to understand that if you miss a deadline, you're basically done. There are very few circumstances where GAO and or the agency are going to grant some extension. So you've got your 10 or 5 day rule to get the protest filed, and you have to appreciate that if you, unlike filing your proposal, if you file your protest, say you have your 10 days to get your protest in, if you file your protest at 4:50 p.m. on day 10, thinking that you are timely because you are within your 10 days, but you're timely for purposes of the stay, you're not going to be, because the GAO is going to have to turn around to the agency and give the agency notice of the protest. And, if offices are closed and they're trying to send over notice of it and they're not going to get it until day 11, the agency's not a notice of it until day 11, then you've lost your stay. The protest may be timely, but the current awardee is going to be able to proceed.
So basically, Jeremy, what would your advice be to the business developers when they are really considering protest? How quickly should they pivot to move, and contact an attorney?
Early. And
What's early? Like the moment you thought of a protest, like literally, like the moment this crosses your mind, you're like, all right, I'm on the phone to my attorney right now.
It may not be the very first trigger that you pull, because you're trying to make business decisions internally. Okay, we lost this, and maybe we kind of expected that we might not actually win this award, or we dumped a ton of money into this proposal and we really thought we were going to have the best proposal. Let's sit down and take a second look, and it might take you a day or two to really, people are working on other matters, but if you're going to consider protests at all, that really has to become a priority. And if you wait until day 7, or day 8 to get a hold of me, then you lose an opportunity to have me look at the protest through a different lens. Because if you have not been through a protest before, what you may not realize is that I need to look at documents that you're going to provide me. We're going to consult with each other probably several times. I then have to prepare the protest. Now it's electronic filing. If you haven't filed before, we have to get an account set up. So there are a number of things that are happening before we even submit the protest. And all that happens is you provide, it just turns into an emergency. And in the course of trying to go really quick, we might miss some really good opportunities. Now, some people will say, well, we can take care of that in the supplemental. But if you don't get to the supplemental, because it's dismissed, then you have a problem. So the
That's
sooner you
really
get
great point. Yeah, and then I think that this is kind of really applies to a lot of things. Like we deal with submitting documents as well by a deadline, and in our field, and yes, somebody can come to us with a last minute, hey, we this RFP has been on the street for the last 10 days and it's due in another week. Let's pivot very quickly, but you understand that the quality is going to really suffer if you do this, and you're going to be burning some midnight oil, and that's going to be very unpleasant for every party involved. And I think that that's kind of a similar principle there. Now let's talk about the forum and jurisdiction of the agency. What are some of the deadlines that are involved in this process?
Well, you can see in the first box we were just talking about the automatic stay. I think I want to focus everyone principally on the center box. Pursuing an agency protest does not extend the time for obtaining a stay at GAO. That's really important, because if you get the extension for some subsequent filing, you don't automatically get this statutorily established stay extension. So the agency or GAO may give you an extension of some number of days, but you aren't going to enjoy the stay extension. So you just have to keep track of that, because you can start ending up with different deadlines, and knowing, well, we might have to submit something a little bit earlier than we wanted to, but if we can get it in earlier, then we're also going to get the stay. That can be a critical decision. If it's a 5-year-long contract, maybe it won't end up being as critical of a decision for you, because there's going to be a lot of work to be done across a long period of time. But if this is more of an urgent need and it's going to be a much shorter duration, then the stay really matters.
But I mean, does the government get irritated when you request a stay? That means that their work is not getting done, because they may not care who is doing the work, but they want the work done, right? So is there a political aspect of that?
I wouldn't, honestly, I wouldn't worry about that at all. I would want the stay, and 9 times out of 10, the client is going to want a stay as well. You want every bit of that contract, and you don't want the other people performing. There will be rare occasion where the need is so urgent by the government that the agency will come back and request that, regardless of when you submit the protest, no stay be put in place, because they really need the project to get moving forward. And if they have to switch it up later because the protest is sustained, they'll deal with that when the time comes.
Okay, fair enough. So then you have that 35 days to resolve within 35 days after the protest is filed. So that do agencies typically follow that set of deadlines, or do they tend to overrun this period of time?
They might overrun, but it's usually, honestly, it usually ends up being a denial that happens sooner rather than later. The place where you get jammed up is you decide to file an agency protest, and you get 6, 7, 8 days in, and you're concerned about the lack of corrective action being taken. And then you can wait until the agency denies the protest and subsequently file to GAO, but now you've lost the stay. So that's why the challenge is, well, if I file my protest with the agency, and I can still file my protest with GAO, but I'm going to have to file that GAO protest before I even get resolution from the agency, well, then what's the point of protesting with the agency? So
Well,
that's
what I'm.
Yeah,
so
that's
it looks like
the ground.
It's pretty much. Yeah, it looks like it's pretty much futile unless it's a very simple kind of matter. Right?
Yes. Yep.
All right. So let's talk about GAO.
So GAO has you can see here I've provided you some of the statutory and regulatory provisions for your reference. Stay of performance is right at the top again, and as long as you're timely, it's going to be granted unless there's this urgency type requirement. And we'll see this on another slide too, but at COFC that does not exist. And we'll go into that a little bit more detail, but there isn't an automatic stay if the protest is to the Court of Federal Claims. There are some jurisdictional issues that we pay attention to. And then there's that bottom component. Yes, the agency protest will move faster because GAO is working on a timeline that looks a lot more like protest being filed. So maybe that's 10 days. Then the agency gets 30 days to file their response. Then you'll get another period of time, the contractor will, to file comments and potentially a supplemental protest. And then the agency again gets its opportunity to respond to your comments, particularly if there are supplemental protest points raised. And then you get to comment on their response to the supplemental protest. So it goes on for some period of time. And then of course, GAO has its window of time to evaluate and make a decision. And then a hearing or a report is set, and you'll go down to, sometimes it's at the agency. It just kind of depends. If it's classified, for example, it'll almost always be in a SCIF environment or something like that for the GAO's decision. And typically at that point, you're then given the option of if it's sustained, if the protest is sustained, meaning you win, well, that's great, you move on. If it's denied, then oftentimes GAO will give you the opportunity to elect whether you are withdrawing essentially, and they don't file a formal opinion, or if they're going to file an opinion. And some clients don't want there to be a track record of formal denials out there. A lot of times it just is what it is. It's now part of the case law that's out there, and that of course is the case law that I rely on when I'm citing for purposes of why your protest should prevail.
So Jeremy, let me ask you a question. So if you're an incumbent, isn't it in your best interest to almost always file a protest over if you lose your contract without the stay, so you can continue working?
That's a great question. It really depends on what else you have in your hopper. But if you are the incumbent and you have the opportunity for a bridge contract, so we are working away hard for the last 5 years, and we've gotten our option years, and now they're maybe expanding the scope, or it's changing in some manner. So there's a new solicitation that goes out. You submit your proposal for it as the incumbent. You don't get the award. You do potentially have a financial interest in protesting so that you can enjoy that 3 or 4 month bridge. That, though, you want to be careful about if you're doing it strictly to get the bridge. So if you're protesting without really colorable grounds for a protest, that I think could backfire on you going forward with the agency, because all you're doing is abusing the system, so to speak, to be able to get additional time out of that original contract. But to each his own. I mean, there are oftentimes colorable grounds for a protest that you may not prevail on, but if there's significant value in a bridge contract, it's certainly a consideration.
All right. So let's talk about briefly about the Court of Federal.
So we won't. Well, so we won't spend a whole lot of time on COFC or the Court of Federal Claims. It's really a much more complicated and burdensome process, but sometimes it's necessary to go this route. I noted earlier, and you see on in the top box there, that there isn't an automatic stay if you timely file your protest. Instead, you have to go through a little more complicated process of filing for a temporary restraining order and a preliminary injunction. I have represented, and my colleagues here have represented plenty of clients who have actually had that granted, but the bar is fairly high here. You know, the court is considering the injunction to be extraordinary equitable relief. So they're not really inclined to grant a TRO. It's only going to be granted based on a showing of usual injunction factors like the likelihood of success on the merits of the case, a balance of the hardships between the offeror and the agency. Would there be irreparable harm without a stay? And then public interest, is there significant impact to others other than just the interested parties? And then the jurisdiction over task and delivery orders. This may or may not be as big of a deal for some of you as others, but it's more narrowed scope. It's got to be that there's some sort of increase in scope, period, or maximum value of the contract. All right.
All right. Oh, skipped one. We need to go quicker. I think we got another 20 minutes left. So deadline.
We can really jump over this slide. This just gives you, I think it's often helpful for all of you who are attending to have some of the, you know, the primary resources to go to. And you see those there.
And so we talked about the 10 days deadline, basically. So is there something that we need to kind of focus on?
The key thing here is, when is it that you knew or should have known, whichever is earlier. And that often comes down to debrief. So if there's a mandatory debrief, your clock is really going to run from the debrief. The key thing to remember here is it's when the debrief is offered. So if the government offers a debrief on Monday, and for whatever reason you just simply cannot do the debrief until Wednesday, your clock is running from the offer date, not the date that you accept.
That's important.
It's very important. But we've talked about most of these points here already. We can go ahead and jump to the next slide.
Yep. So
here, you know, this isn't the headers that are on there. These aren't technical headers that you would find in the CFR. But on the left, you really have what are going to be those pre-award protests, where there's some alleged impropriety in the solicitation. And it's important to understand this because you don't get to identify improprieties in the solicitation and wait until post-award to protest those. You have to protest those prior to bid opening or receipt of the proposals. And if there's some amendment, then that period would be extended out to the next closing time. That's what you see bolded there. For our purposes today, we're really on the right side, which is, again, we're talking about 10 days after the basis of the protest being known or when you should have known. With agencies, it is important to remember that while typically we're talking about 10 days, there are times where the deadline will be shorter. And typically, if the agency is setting a shorter deadline, that will have been referenced in the solicitation, so you'll know that.
That's interesting. All right, so now, what happens You do the filing, and then what do you find out after that?
Well, so this last piece, which is within 21.2A3, the reason it's broken out separately is there are things that you really need to pay attention to when you file a protest with the agency and then are thinking about subsequently filing with GAO. And I was alluding to this a little bit earlier, because sometimes it won't be as clean as the award happens or the debrief date is there. The agency may take other action that should indicate to you that you will not be getting the award. So you file something, very soon before the proposal deadline, and then you think you have a certain period of time to wait, but the agency has taken some sort of action that would indicate to you that they are not going to be sustaining your protest. Because if you protest pre-award, they can't award until that protest is resolved, but they continue on with everything else. They can take the proposals, they can start evaluating and doing all those sorts of things. So it's just important to remember the timelines also concerning the stay versus just simply filing the protest. And then the last point on here down at the bottom, you really don't want your protest to be dismissed. And there could be all sorts of different reasons that it would be dismissed, but one of the classic situations is you're in such a hurry to protest and you protest before the debriefing. So you know you've lost, you go ahead and file your protest, and the government's position there is, look, the debriefing is in part to give you all of the information that you need to know in order to make an informed decision about whether you're going to protest or not. And you're wasting conceivably everyone's time if you're prematurely filing a protest. So
Now, Jeremy, let me ask you a question though. Sometimes you don't get a debrief. Sometimes you get a letter basically substituting a debrief, and the government never meets with you. Let's say that you request a debrief, and they send you some sort of like a PDF file basically that has their conclusions and their findings. And then you are kind of left wondering, well, is there going to be a meeting with them in person, or is this it? If you file a protest at that point, is it prudent for you to go ahead and ask them, hey, will you meet with us, or do you pretty much assume that this constitutes a debrief?
That is, again, a really good question. You want to have documented that you are, if it's not a mandatory debriefing situation, you want to have documented that you're asking for a debrief. So the letter comes out, it says you're not an awardee, and you send an email back. Sometimes people will just pick up the phone because it's expeditious, and that's fine. There's not an issue with that, but you want to put in writing that you've asked for a debrief and that you're requesting the agency to respond in writing concerning the debrief, so that if they don't, well, then you've clearly made a record that you requested it and your time should run. Now, practically speaking, you don't want to be in a position where you wait and the agency or GAO takes the position that you should have known at the time you received that letter. So out of an abundance of caution, I would always advise a client that the date that we really want to work from that earliest date. And if you've gotten a letter saying you're not an awardee, we should be working from that date.
Okay. Let's talk about the process real quick. And I've highlighted here in blue the areas where I think that these are the most relevant to the BD crowd. Right? Some of these are relevant to the lawyers, but these are the kinds of things that business developers really should know.
And the points that are highlighted there, especially the middle two, the detailed statement about factual grounds and the information that establishes that the protester is an interested party, that in great part we're going to be getting from our clients. So I'm going to be coming to you, all of the attendees who are listening, and working jointly with you to identify why it is that you think the technical evaluation wasn't completed properly, or why the agency didn't follow its own evaluation criteria, or why they didn't, they dismissed something concerning past performance, or something that is out there. And there will also be things that, I had a protest not too long ago that involved a late filing of a proposal. And that late filer, that late offeror, ended up being the awardee. And the only reason we knew about the ground of protest was because someone working at the job site, my client was the incumbent, knew from someone else talking in the office about that late filing. And it's because there were internet problems. Internet problems are your problem unless the agency says that they are going to extend. And in that case, then we were able to use an affidavit. So that's an important part of this detailed statement of the legal and factual grounds of protest. And the supporting documentation was, in that process, we actually went to the agency because we felt it was a very clear-cut situation. We had an affidavit from the team member who was working on site and knew the information. And we actually, in that case, we were the incumbent. So we had a bridge for a period while the agency was making its decision, and then it took corrective action, and ultimately we ended up getting the award. So the last point there we've already, I think, sufficiently covered concerning protective orders, relevant documents. We'll get into that a little bit more. But the key point about this slide is, if you don't cover these points in your protest, you have automatically created a situation, or I have created a situation as we've put this document together, for GAO to dismiss the protest.
Yep. And here's some new rules on protest filing. So you talked about the electronic filing. This is a new thing, and classified protests are not filed via the system.
Yeah. You're absolutely right. So now we have this electronic protest docketing system, EPDS, and that means it should be a little cleaner and easier process for GAO in tracking these and being able to use the tools associated with the docketing system to give notice to the agency that a protest has been filed and track dates and all those type of things. But it cannot be used for classified protests. If you're anticipating filing, either you or I will need to contact GAO and or the agency concerning our desire to protest and what process they have in place for classified protests. If you haven't been down this road before, and most of us have not, you want to make sure that you have sufficient time in there to set up your account and go through that process. So we don't want to be waiting until 3 or 4 o'clock on the last day that we can submit the protest. The second bullet on there, that's really my issue. A notice of appearance has to be filed with the protest. Then those last 2 points about the redacted protests, when we file the protest, let's say it's day 10, we file a full protest with all of the documentation, everything unredacted. Then within a day of that, we have to file a redacted copy, and that's because the redacted copy will be made available to the awardee who may want to be an intervener. And then the GAO turns around with the unredacted copy and provides that to the agency. and we then must file with the agency the full, the GAO gives the agency notice, we then give them the full unredacted copy with all relevant attachments. And the last point on this slide is about supplemental protest grounds or an amended protest. Oftentimes you will have a couple points that are really important that provide a colorable protest, but then once we get the source selection decision document and we start getting the proposal for the awardee, we discover, oh my goodness, there are a whole bunch of other grounds for protest. So we'll get into some of those types of grounds here in just a moment.
Yeah, and that's really, really important. That's one of the reasons why a lot of times companies protest. They may not have discovered the most compelling reason for a protest until the lawyers and the expert witnesses start digging. Oh, there you are, Jeremy, again, digging through the documents, the source selection documents, the proposal documents, and they discover, oh, you know, now we can relaunch and do a supplemental amended protest, and now it can be for much more serious reasons. Now the common grounds, Jeremy.
So we're going to go through 2 slides with 4 different types of examples. Obviously, this one on the left about stated evaluation criteria, you know, this is kind of a bread and butter example where the agency has identified in its solicitation the evaluation criteria it's going to use, and we identify that the agency didn't follow its own criteria. And it may be that they simply did not follow the criteria. It may also be a situation where they followed the criteria, but particularly in cases of trade-offs, as opposed to lowest price technically acceptable, that they haven't sufficiently documented the evaluation. So we don't typically have that, of course, at the initial protest. There may be an allegation that criteria wasn't followed, or we may know something that we're able to submit through affidavit. And then once we get the agency report and we get the documents we've requested, we identify, oh my goodness, they really did an extraordinarily poor job documenting and supporting how they got to the decision they got to. So that's a good one. And then on the other side, we see flawed source selection decision, an example there that the agency failed to perform a best value determination or failed to properly perform one at all. So you're probably all aware with a lowest price technically acceptable situation, we're just focused on price. But if we're looking at best value and there are trade-off assessments that are happening between price factors and non-price or non-cost factors, then there really needs to be a detailed evaluation that's done.
Great. Oops, here's a couple of more examples.
So unreasonable technical evaluation. This I would say is the box that isn't the strongest box, but it's often where the protest starts. Hey, we should have gotten all of these other strengths and we didn't get them. We submitted this aspect of our proposal and this technical aspect, and we did not receive strengths for them. Or even worse yet, we received weaknesses where we shouldn't have them. I'll tell you that oftentimes these are not successful because the agency gets a significant amount of discretion in determining strengths, significant strengths, weaknesses, significant weaknesses, and almost without exception, we get an agency report back that says, this is simply a case of the disappointed offeror being disappointed. They disagree with us, but we get deference under, and they'll cite all kinds of case law that does in fact say that they get deference as the agency, and we won't prevail. But if we can start with good grounds in this blue box on the left side, then oftentimes we can find other points that are valuable in a supplemental protest. And then on the right side, disparate treatment between offerors. Of course, we often don't know this at all at the initial protest stage, but once we get the proposal and we get the evaluation documents, we can see, wow, not only did we not get a strength for this particular situation, but the other side did, and they proposed the same thing. So that's not fair. It's disparate treatment, and this is an area where GAO will sustain protests. The catch is narrowly tailoring that argument to be able to say that what the awardee proposed was the same or substantially the same. And that is a challenge for your lawyer. That's a challenge for me because I don't necessarily have all of the technical understanding of why would you propose method or system or model A and the awardee proposed B. Well, how am I able to articulate in a manner that the agency can't split hairs on me to say that A and B really are the same type of thing? Maybe the system you propose or the method that you're going to use is called something else, but it in fact is the same or substantially the same, or ideally even better. So if they got a strength for it, we should get a strength for it too. And if we get a strength for it, or we get multiple strengths, now all of a sudden we win the contract. So the green box is really a great box to be in.
So if somebody else protests, do you just sit and wait till the outcome is known?
No, so typically, and I represent clients in this too, you're the awardee, and the agency is responding to protect its own file, its own decisions to get its contract carried out. Their best interest is not your best interest necessarily as the awardee, but oftentimes they'll ask for input, or you will just insert yourself as the intervener to go ahead and basically prop up the agency to say, here are all the reasons the agency is right, and that's why we still get the award. And this can be critical because the agency attorneys and team that are doing the agency response aren't infallible. They're not necessarily going to get every single thing right. And as the intervener, you absolutely want to ensure that that protest is denied. And so you're really there submitting documentation to say, this is why disparate treatment, for example, this is why our option A is very different from their option B. They're just, hey, protesters just trying, it's all smoke and mirrors. They're trying to say why it's the same or substantially the same, and it isn't. It's a completely different approach. And this is why ours was so much better and why we got the strength and they didn't. So that's really what intervention's about.
So there are three possible outcomes in a protest. Can you tell us more about that?
Yeah, so dismissal is absolutely not where you want to be, but there are some real common grounds for it. It's untimely. The grounds are just really entirely speculative. You're making things up, so to speak. You're just throwing a bunch of noodles against the wall and hoping that some of the spaghetti sticks. Small business size matters aren't appropriate to submit to GAO, for example. Those go to SBA. The other box you don't want to be in, of course, is a denial, that you lose the protest. And then the other option is that the agency takes corrective action, or GAO sustains the protest and encourages the agency to take corrective action.
Now let's talk about this the new development where the protest could actually cost you money, and what are the situations when this is the case, and where do you think this program is going to go?
Well, this is really going to be interesting to see what happens. This one is not in effect now and will not be in effect this year as the program is coming together. So here we are at 1 o'clock, and for the first time, I have seen my own picture up on the webcam.
Yay, winning.
Better late than never.
Right.
But this is really going to be interesting. It's not going to apply to everybody. You can see when it's triggered where a protester has a $250 million revenue in the preceding year, and the protests denied in an opinion issued by GAO. So that matters, that an opinion is issued. It doesn't apply at this point to the Court of Federal Claims. So we're just talking about DOD and protests to GAO. The question that really many people are asking is what falls within that last bullet there, costs incurred in processing covered protests. What the heck does that mean? Well, we don't really know yet. Hopefully we're going to get some more definition. But unfortunately, what could happen is you satisfy the trigger points. You submitted a protest. The fee shifting is triggered, and then there's litigation over what costs incurred can actually be shifted over to the protester. And the whole concept here is to help reduce protesters filing who largely are serial protesters, big companies, obviously 250 million in revenue the preceding year, who may just be gumming up the system. And it's a way to start shifting fees back to them to say, you shouldn't have brought these, and now you're going to have to pay for all of the money that the agency is paying, all the fees and costs they're incurring in defending against the protest. Because who pays for that? The taxpayer does.
And where do you think this program is going to go if it's successful? You think it's going to actually spread across all sizes of companies, or is it just going to stay with the large businesses?
I don't know. That's a great question. I mean, it's going to be a 3-year pilot program, right? So we're not going to know the answer to that until you see September 30, 2022, and then there will be a period of time where they evaluate, well, how did it go? And I'm sure there will be some sort of study set up for that. And then they'll make a determination about, is this something we're going to keep in place? Are we going to expand it? Was it very successful? Did it create more problems than we were hoping it would solve? So we'll see. The jury's out.
All right. So one thing that I really wanted to kind of leave with you guys from this session today is you want to make sure that, okay, there was a protest. Now the government, whether it was, whatever was the resolution, it may have not even been conclusive, but after that, you see the agency changing course. And now they are reissuing this procurement. And it could be that this new procurement has only minor changes. Even though there are some minor changes in this procurement, you should not turn around and resubmit a minimally changed proposal in response to that. We've got to consider these facts. Your competition had extra time to prepare and to improve their approach based on the results of a debrief. So timing, better capture at the time may have actually helped you win this. But now your competition had a chance to catch up. Now your competition had a chance to strengthen themselves. And they also had the feedback. So after it's all said and done, this is a new game. So you have to go back to the drawing table and say, okay, drawing board, and say, how do we win them this time? What factors have changed? What is the new environment? What is the new threats, opportunities? What are the new strengths and weaknesses, and how do they line up? You have to brainstorm, elaborate. You have to improve your proposal significantly. You may even have to sharpen your pencils on the price volume. So in this case, just because you were wonderful, you had a really strong proposal to start with, it may not help you win the second time. So you have to take the situation very seriously and not be complacent. And let's go to questions, guys. We're a little bit over time, but if you have any questions, we're happy to answer them.
And I would say here too, while you're thinking or writing something, you've got our contact information. Calling either Olessia up for a question on more of the capture side or the development side, or giving me a call to follow up on some of the points we discussed today is we welcome that, and hopefully we can help you be best prepared going forward.
All right. Well, guys, I'm going to go ahead and stop the recording. So if you have any questions, just jump in. If not, just send us an email. All right. Thank you very much, Jeremy. And thank you very much, everyone, for attending.